The Local Government Auckland Transitional Provisions Amendment Bill is set down for second reading forthwith.
Speaker.
The Honourable Christopher Finlayson.
Mr Speaker, I move that the Local Government Auckland Transitional Provisions Amendment Bill be now read a second time. The Local Government Auckland Transitional Provisions Act established the streamlined plan-making process, including an independent hearings panel to hear submissions on the proposed plan. This is intended to result in faster delivery of a high-quality, operative Auckland Unitary Plan. The Auckland Unitary Plan is critical to achieving the city's proposed growth targets, as well as planning land use, critical infrastructure and housing supply. To recap briefly, the purpose of the bill is to provide more flexibility to the Auckland Unitary Plan Hearings Panel to help ensure it can deliver its recommendations on the proposed Auckland Unitary Plan to the Auckland Council by the statutory deadline of 22 July 2016. The panel has made good progress. However, hearings on site-specific matters, which are of high public interest due to their impact on individual property rights, are due to begin in January 2016. The panel have indicated that the expected increase in workload as a result of these hearings poses a risk to meeting the statutory deadline. It's critical that the hearings panel is able to continue its good progress and make recommendations to the Council by the deadline. In order to achieve this, the bill has three main components. First, the bill reduces the quorum required for hearing sessions from 3 members to 2 members. Secondly, it's going to allow an increase in the possible number of appointed hearings panel members from 7 to 10, excluding the chair. And thirdly, sir, the bill will enable the hearings panel to make its recommendations on the proposed Auckland Unitary Plan in stages after hearings are completed on a particular topic rather than in one final report. To support these policy changes, additional amendments are required. First, the bill creates a requirement for the Minister for the Environment and the Minister of Conservation to consult with the Auckland Council, the Independent Maori Statutory Board and the chairperson of the hearings panel prior to appointing additional or replacement hearings panel members. Secondly, the bill clarifies that the hearings panel may hold hearing sessions concurrently and that an additional chair may be appointed for the purposes of chairing a hearing session when the chair is unavailable due to chairing a concurrent hearing session. The bill validates any hearing sessions that were held concurrently prior to this clarification being made. And finally, sir, the bill validates 28 February 2014 as the closing date for submissions on the proposed unitary plan. I should also say, sir, there's a minor and technical amendment also required to fix an error in the drafting of the Principal Act relating to the procedural requirements for the filing of appeals on questions of law with the High Court. What was that? Well, that's very kind of the member to say so. It would never happen in Wellington either, because nothing ever happens in Wellington in terms of local government reform. That's a remarkably perceptive insight by the member for Rimataka at 11:35 tonight. Mr Speaker, I want to reiterate that the first Auckland Unitary Plan is of national importance, and the success of the submission and hearings process is critical, as it could set a precedent for similar planning approaches throughout the country, probably not Wellington. Mr Speaker, I commend this bill to the House.
The question is that the motion be agreed to.